Hi, this is Howard Stross, and welcome to Video Tips. These tips are not designed to give strict legal advice. It's merely to give you an introduction to a concept or a principle, something that might be useful to you or you might want to think about so that you can then talk to your lawyer about it. One thing that we get a lot of calls on, and that's what Video Tips is about, is powers of attorney. Durable powers of attorney are mostly used today, and the word durable simply means that as long as the person signs the power of attorney when they are well mentally, then if they should become incapacitated in the sense that they become mentally incompetent, the power of attorney would still be valid. That's the shorthand version of what a durable power of attorney is. It is controlled by statutory law, a law that was created by the legislature in Florida, and it was just recently changed a little over a year ago. Some of the things, though, that I want to tell you about today include formal guardianship, the fact that this is not a panacea to everything, the fact that it is effective immediately, it's like a blank check. There are no instructions associated with the power of attorney, there's no reporting, and it doesn't always work in all states. Let's talk about formal guardianship. What if you didn't have a power of attorney? Well, if you don't have a power of attorney and you don't have a trust that holds the property, you have two options then. Do nothing at all, or someone on your behalf would have to go and get a guardianship established. Now this assumes, of course, that you're incapacitated. If you have capacity, you just do it yourself. The other thing is, it's not a cure-all for everything. It's not going to work in all instances. So, I'll give you one example. Let's say you have a mutual fund, and that's controlled in the city of Chicago. Well, the city of Chicago and folks that are there are not controlled by Florida law. So even if Florida law would compel them to do something, if they were located in Florida, they're not. So it has its limits. That's why many people use trusts. And it is a blank check. In other words, if you have a general power of attorney, and which covers all kinds of activity that the individual could do for you, it's effective immediately as soon as you sign it. So you better very well know the individual you're giving this power to and understand that it's in the wrong hands, it could create a lot of mischief. And that would be putting it mildly. There are no instructions with the power of attorney. It just indicates what the person can do. It does not indicate how, when, or why. So make sure that the individual that you are selecting, you trust implicitly 100%. And again, it's not always honored. And even in Florida, the law was changed so that there are exceptions when even someone in Florida does not have to honor the power of attorney. If you go out of state with the power of attorney, again, it's very important to note that it is not controlled someone in another state by Florida law. So I would encourage you when you're doing estate planning or just for your daily activities, if you think you're going to be gone for an extended period of time, then talk to your lawyer about establishing a durable power of attorney. One last thing is that you can put a power of attorney into escrow and only have it taken out under certain conditions. That might be a safeguard. You should talk to your attorney about that also. Thanks for listening to Video Tips.